Good morning. The Hearing Board of the South Coast Air Quality Management District is in session. Today is Thursday, December 27, 2018. The time is just after 9:15 a.m., and we are meeting in the Hearing Board room in Diamond Bar. We had one change to our schedule for today, and that is Press Forge Company, case number 6126-1 for a short variance has been taken off calendar. And that leaves us with one matter, which is Tesoro Refining and Marketing Company, LLC, case number 4982-119 for a short and AOC. And this was originally requested to be put on consent, but was taken off by a hearing board member. Who is representing Tesoro today?
Malcolm Weiss with Hunton Andrews Kurth. Good morning. Happy holidays.
Good morning, Mr. Weiss, and happy holidays. And who is representing the executive officer?
Nancy S. Feldman for the executive officer.
Thank you, Ms. Feldman. So we are going to have a full hearing today. However, given that we do have the benefit of the consent documents, we can shortcut it by accepting, as the parties have already agreed to do, the declaration of Bikash, and forgive me if I am pronouncing it incorrectly, Sharma. We will, as long as I assume there is no objection by either party, we will accept that as evidence, and we will mark it as exhibit number 1, and we will accept that in evidence. Although we will ask that Tesoro please put Mr. Sharma on in a moment after opening arguments and swearing in for any additional questions by board members or Ms. Feldman if she has any, but I do not believe she will. In addition, we will mark as exhibit number 2 the proposed findings and decision and order granting the short variance in AOC. Because we've already received that and had an opportunity to review that as part of the consent documents as well. And with that, I'm going to ask any witness, any public witness, anyone who wishes to testify today or may testify today, to please rise to be sworn in. Please raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God? Thank you. And Mr. Weiss, if you would like to begin with an opening, this would be the time.
Thank you, Madam Chair. Again, my name is Malcolm Weiss. I'm with the law firm of Hunton Andrews Kurth. I represent the petitioner Tesoro Refining and Marketing today. Before you is Tesoro's request for a short variance and alternative operating conditions, the AOC. The case number is 4982-119. The request, as you already noted, was initially filed on November 30th as a consent calendar item. The basics here are that the number 1 reformer heater is going to be taken down for a scheduled turnaround. While the heater is offline, some of the heater's convection section tubes will be replaced, but the heater will be shut down and not generating any emissions. The overview is very, very simple. It's a scenario that I think this board has heard on multiple occasions in the past and that have been on the consent calendar multiple times in the past. We have the scheduled turnaround. It's occurring to maintain the basic equipment, the heater. As part of the process, some of the heating tubes are going to be replaced because some of the heating tubes have just deteriorated over time. And that's just part of standard maintenance to ensure continued safe operation of the facility. To do the work, the heater is going to be disassembled. The fuel line to the heater will be blocked and disconnected. And the emission stacks where the SEMS is will be taken down. There's actually 2 stacks. The district rules require the SEMS and the alternative SEMS data to be produced at all times. But due to the work being done, there will be no data to provide to the district as required by district rules. So as at this variance, there would be a violation of the district rules. So Tesoro is behaving as a good corporate citizen, doing what the district rules and regulations and state and federal laws provide for. They're coming in proactively to get variance coverage from the missing data provisions. There will be no violations of the law except for those relating to the SEMS and the ASEMs. There should be no innuendo that Tesoro is doing something wrong or is asking for relief that is not appropriate. The way the rules are constructed, we have to have variance coverage or else we would be in violation. So this strikes us as a very standard consent calendar request. There will be not only no excess emissions, there will be no emissions. In fact, driving out here today it created more emissions from the folks that drove out here than are going to occur during this variance from the equipment. Again, it's a scheduled turnaround. We're taking that opportunity to fix some other things, but the main point is that the SEMS and the ASEMs will be disconnected. It's a very pragmatic example of the variance in the AOC petition that should remain on the consent calendar, and we hope that in the future that it will. As this hearing board has established in its own rules on the consent calendar is a procedure for expediting the presentation of evidence at the hearings, which I understand we'll be able to do today, and I appreciate that. But it's also in a case where the district supports the variance request. I don't think you'll see a clearer example of a case that the consent calendar procedures were established for other than the one before you today. That said, of course, we're here. We can put on direct testimony, but my preference would be, as we've done in the past, is to let the board members have their questions answered as succinctly, as directly as possible, and then move forward from there. If we need to put on a full hearing and have the witness testify, we can do that. But again, the witness won't be saying it or presenting any evidence that you don't already have before you. So the district supports the variance request. As you're aware, the board has previously granted variances from these district rules when a SEMS or an ASEMS must be disabled or disconnected. The fuel line is going to be completely blocked, both by a blind, and there will be a physical gap between the fuel line and the heater. The stacks where part of the SEMS equipment resides will be lying on the ground as opposed to connected to the heater. People will be inside the heater doing some work. There will be no fuel going in. So as you're aware from reading the already submitted papers, it's clear that all necessary findings can be made. There is no risk of any excess emissions or emissions because the emissions generating equipment will be shut down for the entirety of the requested variance in the AOC period. Therefore, in the interest of efficiency and to conserve the parties and the board's time, let's focus on the question that any board members have. This way we can respond specifically. And if we don't address all the concerns, as I said, we will go ahead and put on testimony. And that concludes my opening. Thank you.
Thank you, Mr. Weiss. Ms. Feldman, any opening?
Yes, thank you, and good morning, members of the board. Obviously, the district has no opposition to this variance. If we had, we would not have agreed to have it heard on the consent calendar. I also concur with Mr. Weiss's suggested approach that both parties simply entertain questions from hearing board members so that we can address whatever concerns you may have that might have caused this to be taken off the consent calendar. I just want to make one brief clarification. I did note in Council's opening, he stated that Tesoro was seeking a variance from missing data provisions. In fact, Tesoro is not seeking a variance from missing data provisions. It's the permit requirements and rules that require that the SEMS and ASEMs be connected and operational. Mr. Sharma's declaration makes it very clear that the missing data provisions are not the subject of this variance, and that's in paragraph 9 on page 3 of his declaration, just so that you can confirm that. That being said, again, the district has absolutely no opposition to the variance, and we are also a little curious as to why it was taken off consent. Thank you.
Thank you both for your openings. As we had stated earlier, I am intending to proceed as the parties have requested. That was definitely the intent, to proceed from the declaration now being in evidence, as though Mr. Sharma had testified as to it in person. And so I will turn to board members for any additional questions.
Mr. Weiss, we're here to ask questions and expect answers. Sure, there's pollution every time you get in your automobile. If I have questions about this refinery, that's had problems in the past.
I'm sorry, but that could be part of deliberation.
I know, but that's what he's.
For the reasons why you may, no, I'm sorry.
But I'm sorry too. He mentioned that early on. Sure, it's part of deliberation. That's true, and I understand that. But wait a minute now. Come on.
If you have questions.
I'm explaining to Mr. Weiss why we're here and why this is off consent. It was kind of arrogant in my view.
Then ask, if you want to show Mr. Weiss why, please ask the questions for which you took it off for.
Madam Chair, let me explain one thing to you. The fact of the matter is that as a member of this board, I had the right to take it off consent, which I did, and not to be reprimanded for having done that. Giving a reason why it costs more in terms of admission to come out here for this hearing than it would be otherwise. I resent that.
You may proceed with your questions.
Testimony from I want to hear from the declaration of Mr. Sharma.
Okay. We can introduce Mr. Sharma. We can have Mr. Weiss do that. And then you will need to ask specific questions that are not covered by the declaration. Please introduce Mr. Sharma. Mr. Weiss.
Ms. Sharma, can you please state your name and spell your name for the record?
My name is Bikash Sharma, Bikash Sharma.
Mr. Sharma, have you been administered the oath today?
Yes.
Can you please describe for the board your position with Tesoro?
I'm Senior Environmental Engineer.
And what are your job responsibilities as Senior Environmental Engineer?
I'm responsible for compliance with the SCAQMD's Reclaim program and also all the permit conditions associated with the Reclaim program.
And are you familiar with the district's permitting program, the Clean Air Act's requirements, and the specific rules that we will be discussing today?
Yes.
And are you also familiar with the permit that Tesoro operates under, the air permit?
Yes.
Have you reviewed your declaration and other documents submitted to the board as part of this matter? And can you attest to those documents being accurate?
Yes.
That's all for right now. I'll turn it back to the board to see if they have any questions, and then I can go farther on my direct if I need to.
Thank you. I'm going to let Mr. Balagopalan ask.
Dr. Lanoza before me. So.
I'm sorry? Unless the senator, were you ready to ask your questions? Okay, go ahead.
Oh, okay. Mr. Sharma, my question, I'm actually having difficulty looking at finding a violation, so I wanted, my questions are related to that. So let me see if I understand it right. You have two stacks on the heater,
Yes.
you know, and they are, I'm going to put this here just for prop, if you don't mind. I was trying to use the pink, but I don't think it'll stand. But so those two stacks have right now they're operating and they're measuring NOx and the fuel flow and so forth, right?
Right.
And when you go through the shutdown procedure, which is what you're going to do to take the heat offline, it'll still be recording until it's all shut down.
That's correct.
What happens after shutdown? What kind of data is sent to the system?
There won't be any data.
There won't be any data because...
SIMs will be completely disconnected and stacks will be completely
So when you
down.
say the SIMs will be completely connected, you're talking the probes will be removed from the stack and taken down?
That's correct.
And the SIMS unit is turned off, basically. So everything is down to do the repair.
Correct.
And then, so nothing's operating. And then I think in your petition says you know, that it's pointless to bring a rental or anything because there's nothing to measure. And really, if you want to measure, you have to have a stack with the probe to measure anything.
Absolutely.
And it's a 40-foot stack, you're bringing it down, so nothing is, so there's no emissions during that period. The condition to even do anything, I mean, there's no monitoring really being done at that time. Even if you wanted to, you cannot do it.
Absolutely.
Okay, so I wanted to be clear. Now, let's say that it's down, you brought it down, and it's not sending any data, and how do you know to the district, I mean, that there's why the reasons no emissions have been reported in those 45 days?
Well, we will have completely shut down of the units. Units are completely dismantled, and SIMs will be completely taken off of the stack. So there is nothing to monitor, nothing to measure. Power will be completely down.
No, but if the compliance staff is looking at the records a few months later and say, okay, there's not missing data, but there's 45 days of no data, and the reasons why, would that be noted somewhere, or is that something that can you add it to the SEMS system to indicate that the system's down? Or?
Yes. So there are a whole lot of codes which indicates that unit is completely shut down
Okay. Now,
or non-operational.
okay, thank you. So once, you have to take it down to do the repairs.
Correct.
Right? And then, but once the repairs are done, the stacks will come back up, right? And the probes will put back in.
Correct.
And the SEMS will be on.
Correct.
And you have to operate that, and let's say, this is your heater, even if the heater is not back online, the rule requires that you have this up and running.
Correct.
And that's what you will do.
Yes.
So that's compliance, because then you can actually do what the rule requires, because even though the heater's offline, the probes are there, and it should, and what do you do daily? Is it daily calibration?
Yes.
And what else? Weekly?
Well, we have daily calibration, weekly QA/QC, monthly QA/QC, and all the quarterly QA/QC.
So all those can be done because the stack is back up again.
Yes.
But during the shutdown, nothing can be
Nothing can be done.
reported. Okay, so during the startup, what's the plan? How many days roughly after the stacks are up and calibration and everything that will this be turned on?
Well, we don't, SIMS will be in full operation before we even introduce the fuel to the unit.
And typically, what would be the time frame before that the fuel is introduced?
I don't know.
You don't know?
It depends on turnaround schedule.
Day,
But,
2
SIMS
days?
will be in operation.
Yeah, no, I understand that, but it'll be a couple of days or whatever? Or
Probably a week, I would say.
a week? So a week, it'll be doing as per the rule requirements where to monitor and measure. But you can't do it when it's down.
Correct.
Right? And so that is why I'm having a difficulty finding a violation, because there's nothing you can do, because there's no reporting, there's nothing, even if nothing is on, I mean, there's no stack, no measurements, no SEMS is down, so it's a non-event in a sense, there's nothing going on. So I can see the violation if you have to stack up and this is not up, and you do the going to go through the startup, and you say, no, we don't want to do the calibration, we don't want to take this off. We also, but you're not going but your petition is not for that. Your petition is during the turnaround when you're doing repairs to the heater, you have to take this down. And my understanding, you have to take this down?
The petition is for the SIMS part, because SIMS will be non-operational.
But you have to take the stack down to do the repairs?
Correct.
You cannot do the repairs without the stack?
No.
So once the stack is, go ahead, I'm
To
sorry.
remove the convection section from the heater, you have to take entire top part of the heater should be dismantled completely.
Okay.
And I agree. So the current rule language requires us to have continuous emissions monitoring system in operation all the time, regardless the operational status of the
And
unit.
I agree that the rule requires that, but the subtlety is that when there's nothing, it's not possible to do it. I'm having a difficulty trying to see, okay, where is the violation then? Because there's, and I'm going to refer, we had a case last week, and we had Rule 1110.2, and so I read through the rule, and there was a section actually which sort of not validated, which I thought was coming off field by trying to say I don't see the violation, but I saw a language in that Rule 1110.2, even though it's for an engine, but it says notwithstanding the requirements of 218 and 218.1, there is a language that says stop operating, calibrating the SEMS during any period the operator's continuous record the engine was not in operation. So district staff at some point had made this change, and I looked it up, it was in 2012, so I couldn't find in the staff report what the reasons were. And maybe there's more frequent turnaround on the engines, and that's why they put this so it doesn't have to come to the hearing board, you know. How often is your turnaround for this type of repairs at your refinery?
Each unit probably will go through 4 to 6 years.
4 to 6 years, yeah. So, and that's the difficulty, you know, the first finding we have to make is a violation or a potential for violation. And I was trying to think of an example to relate it to, you know, speeding the car or, you know, but you know, the one thing I thought of this morning while I was shaving was, and if you can indulge me on that, was, you know, if let's say if you're driving and you get into a car accident and you're accused of being on the cell phone, but it's easily verified. You can take the cell phone records, so this continuous capture of data when you were on, exactly what time you're on and what time you're off. If the data shows you're not on there during the time, they cannot cite you for that because that's what the data shows. There's no activity. You know,
Is there a question, Mr. Balagopalan? Because rules say what they say. So if you have a question,
So,
that would be the
where,
time to
okay,
ask that.
and maybe, maybe district staff can help me. Where is the violation when everything's down and you actually cannot do any monitoring?
If I can, as you saw in the petition that we submitted, we raised the same issue. And so all I'm
Senator, I'm
suggest-
sorry.
The attorney testifying, or should we
No,
have an
the
expert?
attorney is giving a legal
The
explanation.
expert witness should be doing that.
The expert witness is not a legal witness. If Mr. Weiss is giving a legal explanation, then it makes sense to come from the attorney.
So I'll finish up very briefly. As I indicated in the petition, we highlighted that issue as well. You're asking for a legal conclusion that I think is best answered by the district.
Okay, and I'll wait for that. Thank you. That's all I had.
I think it's a valid question to be asked of the right person, I think. I know Senator had questions. Dr. Lerner, after that, you may ask your question.
It's called a come see me rule, even though it's not needed. My question is to you, Mr. Sharma. In your declaration, you talk about maintenance of the equipment and why this part had to be replaced. You said schedule, maintenance, and turnaround. What is that turnaround? What do you mean by that?
So every 4 to 6 years, unit has to go through thorough inspection, and all the repair works, whatever needed to be done, they will do during that turnaround period.
How many units like this are operating at that plant site?
How many years?
How many units?
So,
You have more than one heater operating out there, right?
right, so whole
How
reformer
many do you
unit.
have all total?
So one unit, which is called reformer unit, that will be in turnaround in January.
I asked you a question. How many units that operate at that site like this one does?
We have hundreds of heaters.
That's the answer to the question. You have hundreds of them. So not only can this problem happen for one that's
Yes.
before us today, it can happen to the other 99, correct?
Eventually, yes.
Okay. Now, you're saying this is a regular turnaround, regular maintenance schedule,
Yes.
okay? Then why in your your declaration, you say this is an unexpected leak? Why would you say that?
Well, at the end of first quarter, operations noticed there was a slight leak from the convection section tube, but our operations were able to bypass those leaking convection section tubes and then still able to operate the unit with compliance. So half of the convection section tube is bypassed. But since we already have turnaround schedule in January, we were able to run the unit with half of the rate until next turnaround, which is in January, when they are planning to replace that leaking convection section tubes. So which is like they have other work schedule as well, but this will be added in the turnaround scope as well. So when they shut the heater completely down in January.
Are you saying that even though they had a leak in this part, in this convection device, you could still operate? Is that what you're saying?
That's correct, but at very half rate.
Well, were you emitting at that point in time?
No, so
In
convection section tube is, the purpose of convection section tube is to heat the water to generate the steam. So that's why whatever was leaking, it was just the water. But we still have to isolate, and then we would be able to run the unit without any compliance issues.
How many times, your knowledge, did these units have any failures, like the one you just explained?
This is the first I am dealing with.
What about any other 99 that's operating out there?
They are perfectly fine.
Never had this kind of a problem
I
before?
don't know in the past, but they are operating in
You
compliance.
don't know?
So I don't know. So if they don't have any convection section issues right now, but they will go through all the inspection and everything during their own turnaround schedule.
A turnaround to me implies that it's a reliability program in effect.
Can you say that again, sir?
The turnaround maintenance program suggests to me that there's a reliability program in effect. That's in effect.
Yes.
And tell me about it.
So, well, we have entire inspection and reliability group go through each and every heater periodically to make sure that we are,
Come on,
they
tell
don't
me.
have any.
You have what?
So our inspection group will go through all the inspection program. They have their own program, and then they'll go through reliability of the equipment and then determine if units need maintenance or repair or something like that. And they do that during every shutdown period, which is 4 to 6 years normally.
How often do you perform the inspection program?
Inspection have their own schedule, which I'm not aware of.
Well, do you document what's right or wrong with the system when you do that?
That's right.
You have a record that you keep of it so you can share with the district?
They do their own record keeping.
They keep their own record keeping?
Yes.
Why would they know and let you tell them what the problems are?
I'm sorry, could you repeat that question? I'm not sure that it was clear.
I asked whether or not a record is kept of the inspection when they do it periodically from time to time to determine what's right or wrong with the system. He said, yes, they do keep a record. I said, do you share that with the district, those problems, so the district can be made aware? He said, the district keeps its own records. How can the district keep records when they don't have access to the information?
I don't know the specifics. If the
I'm
district,
asking him. Go ahead.
Well, I don't know if district ever asked for that kind of record, because that is inspection program, maintenance and reliability program, and district probably ask. Well, we work with district all the time to provide all the emissions related data, but not inspection related data. So
If your program is, you perform the inspection to determine whether or not you have 100% efficiency of the operation of the equipment, and if you don't, or you're likely to pollute NOx or SOx through the SIM.
sorry, can you repeat?
I'm sorry about my voice. I'm really
That's all right. So yeah, we'll try to respond to all your questions, but I just need to understand.
If during your inspection, from time to time, if you note that something is not operating at 100%, is it likely to fail at the SIM inspection level where you're emitting more NOx or SOx into the atmosphere?
Well,
Could that happen?
So our field operations folks looks heater almost every day. So they have their own daily visual inspection program. If they see anything wrong, they will probably shut the unit down. If it's significantly harm to the environment or people, they'll shut the unit down completely. So that's basically daily inspection program. But periodically, our inspection and reliability group goes through the unit as well. So
Have you known, if you have any knowledge that they were shut down before for those reasons after inspection?
no.
Never had a shutdown.
I mean, particular this unit?
Or no, any unit.
Yeah, they will shut down if they need to be shut down.
And when you shut down, there's a startup time. Do you ask for variance when those units are shut down? Yes or no?
Just to shut the unit down, we don't need variance.
Well, what if startup, there's going to be emission?
Senator, if I could, are we going far afield of the
No, we're
subject
not.
of this
No, I'm
variance
trying to
request?
I'm trying to find out what the standard practice and procedure is.
Yeah, startup and
as it
shut,
relates to this system.
This is quite a complex refinery. Are
I
you looking to
understand.
go into the
Madam
history?
Chair.
Okay.
I'm not asking a legal question. I'm asking it, no, it's not legal. Go ahead.
SIMS is in operation all the time. So any emissions during startup, shutdown, malfunction, everything is documented, recorded, and reported to SCAQMD on a daily
You
basis.
share that with the district
Yes, every day, daily.
on a daily basis.
Yes.
Okay, now what about preventative maintenance? If the life expectancy of this device, convection device, what is the life expectancy of that device?
I don't know, sir.
So you don't have a maintenance program if you don't know.
Well, I'm in environmental group, so I don't handle maintenance part.
Have you ever studied the maintenance program that you have in place?
We do.
Reliability program is part of it?
We do.
So you have no idea about it?
That question's been asked and answered.
No, it has not.
He said he didn't know.
Well, I mean,
He said he didn't know.
Sustained. If you have a different question,
well,
we'll move on.
No. I'm not trying to railroad this at all. Maybe you are. I call it special because I wanted some questions answered. Sir,
My only comment was that he answered
I
it.
want some questions answered. That's why I asked him.
Oh, so you're waiting for my response? Sorry.
Go ahead. I'm waiting. Yeah, go ahead.
Yeah, I don't know. I am responsible for reclaim compliance program, so maintenance and reliability part, I don't know.
Right, and as such, as it relates to your responsibility, do you have the occasion to sit down and have meetings with the other persons who help put this system together and cause it to operate one on the highest efficiency?
I didn't quite understand, sorry. Can you please repeat?
Do you meet with other personnel, other members who are experts in these other fields and try to obtain or learn whether or not you can improve the efficiency of this system?
Well, if they have any concern related to environmental issues, they contact us, but that's their program. They know what they are supposed to do. They have to comply with all other requirements. They have to comply. So I don't know. So if they seek our help, we'll provide them all the help we can in terms of environmental compliance.
See, the questions are important. I think I can ask these questions because this is not the first time this problem happened. In 2013, I think you mentioned there was another one.
Yes.
So therefore, there's got to be some notice given from then to now is what one might do to improve the efficiency of the system.
Well, these are the parts. It can deteriorate all the time. So it's like our car, So we go to mechanics. Mechanics tells you, okay, this needs to be fixed. So it's exactly the same situation. So it's big unit, very complex unit. Parts can deteriorate. Parts can be replaced. Parts need to be fixed. So
In your declaration, you say that You can get all this done in 45 days.
Yes.
Could you advise where in his declaration you're looking so he can look at it? Familiarize himself with it, please?
We wrote it. I'm not going to tell you what page it's on. It says 45 days.
Yes, so,
You may take your time if you need to refer.
Yeah, go ahead. I'll wait until you look at it.
Go ahead, he's familiar with it. Can you repeat your question, please?
Question was, you saying it takes about 45 days to complete the project, all the repairs, is that correct?
yes.
What if it's not done in 45 days, then what? Is there any reason why you think it might not be done in 45 days?
So we will, so normally, historically, we have done in 45 days, but if we,
Say that again, historically?
yeah, in the past, we have done, the turnaround is completed in 30 to 45 days, so we are hopeful that it will be done within 45 days, or even before 45 days, so.
Well, hoping may not make that happen. In the case that hoping doesn't happen, then what's the longest period of time it's taken you to make these kind of repairs?
I don't recall if it took longer than 45 days.
You don't recall that? No. Okay. In that case, looking at the order, proposed variance, page 12,
Sorry, you're looking at what again, please?
the
Exhibit
proposed
2,
variance
the
conditions.
proposed order, page 12, I believe.
Yeah, then I'm looking at, to tell you where to go look, and then you flip to page 12. Oh, I just thought I want to call this special so I can ask some questions.
Okay, if they're relevant to your findings, please ask.
Okay, on section 9, that's line 23. You're saying the variance, you stipulated to this, the variance period shall end no later than February 21st, 2019, or when Tesoro notifies the clerk of the board. What do you mean that or? Or really eliminates then that date becomes moot.
Whichever comes first.
Whichever comes first, right?
I understand whichever comes.
So the date is no longer moot.
It says, but whichever comes first doesn't apply, or supersedes whichever comes first.
No, it does not. It further elucidates or. It's either that date or sooner.
Then on page 14, you address the same issue again, line 2. And the or says when Tesoro certifies. I mean,
Whichever first occurs,
or when they certify. What if you don't certify then?
then it's February 21st, 2019.
What if it's not certified within that time period?
The AOC lapses.
It may not be certified in that time period if the 45 days is not met, and by February 21st, 2019, or then you don't need or when Tesoro is certified. Just put the date in and strike or. You don't need or.
It's in case, we will ask, is that in case it ends sooner than February 21st? It's certified sooner than February 21st,
You gotta change
2019.
that wording.
Is it in case of final
Is this a legal
compliance?
question or a testimony?
If it's a legal question, is
The
the
answer is
reason
yes.
for
The
the
answer is
or
yes. The answer is
in
yes.
case final compliance comes before February 21st, 2019?
That was the intention, correct?
It's got to be so stated.
It is so stated.
No. Or makes it moot.
It does not make it moot.
Well, you say, or when Tesoro certifies, they may not certify before that date.
Whichever comes first. We can't go back and forth. It says what it says.
Well, you know, if you want to give them a loophole, would be my guess and go ahead. But I don't think that's properly,
That is exceptionally common legal
that's not
language.
assertable. It's only, when it's assertable, it's true. If it's not assertable, it's just a generalization. Not
Okay,
assertable.
Senator, do you have any other questions?
I'm not the petitioner here, so you don't have to be on tough on me.
I'm simply asking if you have other questions.
I know, yeah.
Because Dr. Lerner had a question.
No.
Ms. Bird does too.
No,
Madam Chair, would it help just to read that entire sentence into the record so
Go
that it's
ahead.
clear?
Yes, please, Mr. Weiss.
I'm entitled to an answer, even though if I get cut off from time to time.
Okay. The entire sentence, just so it's clear for everybody, says the AOC, the petition, the request for the variance and the AOC, and then it says, shall end no later than February 21st, 2019, or when Tesoro certifies in writing that the SEMs and the ASEMs serving the heater are again in operation and transmitting emissions data to the district on a daily basis, whichever occurs first, period. End quote.
Thank you. Question, Senator.
Therefore, then if it's not certified on that time period, then what's the decision?
Are you asking,
if
are you
it's-
asking a question of Mr.
I'm asking
Weiss? Or who are you
Whoever's going
asking?
to answer this one,
Okay,
if
I
it's not
can-
certified be prior on or before that date, then what happens?
That, to me, is a legal question, and what will happen is we will either be out of compliance with the terms of the variance, or we will come back in and seek an extension.
Okay, thank you.
Dr. Lerner, you had a question.
First, let me apologize to the people in front of me and my confreres for being late. It's the second time I've overslept. I need some help from Mr. Sharma. You said that, can you repeat, I think you said it, when did you discover the leak?
At the end of the first quarter, 2018, this year.
Okay, so that would have been through March.
Yes,
So from March to November, the variance wasn't filed, is that correct?
variance wasn't filed.
Okay. You said in your statement here that if some of the convection tubes are not timely replaced, they eventually will cause a breakdown or catastrophic failure of the heater and number one they replaced. They will eventually, okay, therefore, some of the convection tubes must now be replaced. Must now means then when you discovered it. Can you explain to me why you were taking, so to speak, I mean, from a naive medical point of view, a risk, a mild risk, a breakdown, or a catastrophe between the end of March and the end of November?
So right after we discovered the leak, we were able to bypass those leaking convection section tubes. So half of the tubes which were leaking is non-operational since then. So we were able to run the unit with all the compliance, but only with half of the section. So that's what I meant.
And that lowers your compliance, I mean, the issue of compliance, because you've run it at a lower rate. So it's going to, if it were out of compliance at a lower rate, you would have been here much sooner because that would have been bordering on the more catastrophic side. Is that correct?
Well, we just don't want to run with the
Okay.
leak. So we were able to run without, with the properly functioning convection section tubes.
Then why isn't the whole refinery run at a lower level? Okay, that's a, you know, anyway, I understand. Okay, now, you said earlier in response to the good senator's comments that the turnaround time is 4 to 6 years. How many years since the last one? Is that the 13th? So that would
This
be,
particular unit,
yeah.
yeah, schedule is 4 to 6 years, so I don't know the last turnaround. when
Yeah,
was
I
the
think
last
it would
turnaround
be
done.
very,
So 13 was different units, if you're talking about, so.
it would be very important to know how many years has gone by. In other words, if this is the 6th year, then the planning, it would seem to me that you would have come before us to get the variance sooner than November, and you would have come to us let's say, a month or two after March when you discovered this, because you were coming to the end of the road. So I think it would have been very important if you had presented, or if you know of the information about how many years had gone by before you discovered this, and now we know that you're going to do it in January. And if you or your attorney can help me out, I would appreciate, because I want to continue this matter just a little bit further.
Yeah, so normally schedule is 4 to 6 years, but I don't know when exactly this particular unit were in turnaround previously. So, but
we will-
turnaround is,
Excuse me, we will see if we can get that information for you. I'm not sure if we'll be able
Okay.
to.
Because if it were 4 years and it's already leaking, it would seem to me you would be here quickly.
It should be.
And if it were not 4 years, I still think you want to be here quickly, because you have a right to do the turnaround in 4-6 years. It doesn't say January X date 2019. And so it would seem to me that the prudence, since you brought the question up and you said, I quote, they will eventually cause a breakdown or catastrophe. That strikes me from a health point of view, the safety of the people that you supervise, all the people at the refinery, plus the community adjacent to the refinery. It puts them at risk, I believe, unnecessarily. And I'm looking at this not from an engineering point of view, I'm looking at it from the point of view of just health, that this is something that is preventable. And it would seem to me that you would, why haven't you acted more diligently and quickly? Here we are, it's just a handful of days before New Year's.
sir, so we, like I explained, Senator, earlier, that we do have our inspection program. If I recollect, inspection performed in January did not indicate any issues. So this leak was unexpected. That was discovered in March.
Yeah.
You may ask another question. Yeah, if you want to
I
respond,
wish I were lawyerly enough to phrase it as a question.
Right after we discovered,
but if you wish to have any discourse, you save that for deliberation. But if you have questions that will help in the discourse, then now would be the time to ask the questions.
I'd be glad to hear what he has to say.
He will hear what he has to say, Senator. We're trying to do this in an orderly time
understand.
period.
But we're not in defense of the petitioner. We're trying to get the information so we can make a decision.
Exactly. If there's questions to get additional information, this is the time to do that, Senator.
Madam Chair.
yes, so
Dr.
right
Lerner,
after,
do you have any other question? Did you have?
yeah, right after we discovered the leak, we were able to bypass entire leaking section and then lower the rate almost like half to basically minimize the damage. So we did proactive approach right away. We started lowering the rate. We bypassed the entire leaking section, and heater was able to run. And our expert determined that we can run for some time until next turnaround, and then
Sometime is not, I mean, we're both not lawyers, but sometime doesn't sound like a whole lot of information Do you have a better word than sometime?
They determined that these tubes can be replaced in turnaround.
Yes, but carrying your logic out, if all 100 tubes were developing leaks sometime, then you would be down by 50% because you have lowered the amount of flow so that you can keep the emissions minimal and still accomplish work. So the next question is, and Ms. Prusak may say that it's out of order. Are there any others that are currently leaking that you have not brought before the board?
No, as far as I know, none. Otherwise, we would have known.
I think I have some other questions to ask, but I'm not sure I have them clear in my head because I have to finish more coffee. But thank you for your answer.
Thank you.
Ms. Byrd. I just, these are facts, I believe, that are clear in the declaration, but are you currently operating those leaking tubes? No. Okay. So you are not currently out of operation, is that correct? Out of operation? I'm sorry, out of compliance. My apology.
No.
Out of compliance.
It is at half rate, and also the leaking material was water.
And is there an emissions advantage to the communities that surround this facility to have this done during an already down period as opposed to shutting down and then restarting at a different time and causing those emissions increases?
Yeah, when unit is completely shut down, so that's the time we would like to do it because that prevents us from shutting down at different time again. So emissions during startup and shutdowns are always higher, right? So that prevents us from.
By aligning the timing to an already occurring shutdown, you are minimizing the number of shutdowns and startups, is that correct?
Yes.
Okay, thank you. Ms. Byrd.
My questions were along the same line. Just for the records, I mean, some things are clear to me in the declaration, but for the record, you are in compliance, and you said just now that the leak was what material that was
Water.
leaking? It was water. Okay. So the leak was water. You are in compliance with the district. The rationale for the turnarounds, can you just give us, I think some of us have heard a lot about turnarounds over the years, but can you just give us your understanding of the rationale for turnarounds?
Well, turnaround is basically, it's like, simple example is like, when your car goes through like manufacturer's recommended maintenance schedule, right? So that's when they look everything. And if they find any issues during turnaround, so turnaround is pretty much like they shut the unit completely down, open everything, and then they go through inside and outside of the heater to find any issues they can to fix the problem. Or if they already had found any issues, they'll basically fix fix the issues during this turnaround. So it's basically complete shutdown and open up situation.
And the facility is in compliance with all reporting and monitoring to the district at this time. Is that correct? Okay. And let's see, I just had one more. How frequently is the district on site at the facility?
We work very closely with district, so they do audit once a year for all our facilities. They also come for Blue Skies audit. They call to check leak and everything for Rule 1173 and 1176 once a year. So, and if they can visit anytime they want, and we work very closely with them. We provide them any data they ask for all the time.
And you're in compliance with all the data that they have requested from you? Okay. If you had not, well, turnarounds are scheduled in advance, correct? And so when you saw that you had a leak, and I know this is in the declaration, I'm just putting it out there on the record. So when you saw you had a leak, you realized that that leak of water, that you could postpone repairing this pipe to a time where you were in a turnaround. Is that correct?
That's correct.
And the purpose, as Ms. Prusak was discussing, the purpose of deferring maintenance to a turnaround is to minimize emissions. Is that correct?
That's correct.
Okay, thank you.
Dr. Lerner had more questions.
I'd like to come back to the time schedule. The time schedule in January, was that fixed how long ago?
What do you mean?
The time schedule for the turnaround, which is scheduled in January, which is the reason why you're here for the variance. When was that scheduled? How long ago?
Yeah, we have whole turnaround group decides work on schedule, sir. So
What I'm trying to get at, very candidly, not so candidly, is the fact that would the presence of reducing the convection tubes by a certain percent because of the leak, would that push the group that makes that decision, and maybe you can't answer that, to push the turnaround up? In other words, maybe in the summertime, or is it sort of all locked in a way? Because you said it's a 4 to 6 year turnaround. It sounds to me like you have a fair amount of play where you could hustle this through. And my question is, why did you not consider it hustling through? Again, in your own words, because a breakdown, or more importantly, a catastrophe. Now, in medicine, we think about catastrophes first. And I'm sure you guys, your company does also.
Absolutely.
So my question is, when you knew at the end of the first quarter, why didn't you get it done and come here and get this organized at the end of the second quarter, at the end of the third quarter? You waited to the very last quarter to do this in November.
Well, if I understand turnaround, then turnaround is big work, and we bring all kinds of specialists from all over the world to take care of specific units. So it's big work and requires lots and lots of expertise, manpower. So it has to do with their schedule, our schedule, and I think, and we were able to determine that we can at least run at extremely lower rate until the turnaround where we can, when things can be done, everything together. So it's big work, so we had a lot of manpower from all over the different companies.
My question is about vulnerability. That's the real question. You can push other groups that are scheduled for routine turnaround that don't have this problem. But if you had not said these words, then I wouldn't be asking these questions. I think it's fair to say that if you're vulnerable, you don't wait almost a year or 9 months. I think, and what I'm trying to ask is, why? Were there other ones that were even more vulnerable? Or was it just the volume of work and not enough manpower? I mean, is there a reason why this is going on this way?
Well, like I explained earlier, our inspection department determined that it is safe to run at half rate, bypassing all the leaking tubes until January turnaround. So,
Okay, let
May I
just ask one other question, please.
Senator, I was not going to interrupt him. Thank you. If I had a question that was, never mind. Please, Dr. Lerner, ask your
Okay.
question. This is not necessary constantly.
Sometimes.
Well, I pass.
Dr. Lerner, please ask your question.
The question is, the question that somewhat logically follows, were there more vulnerable events that forced you to wait till January? In other words, why couldn't have this been done sooner?
like I said, this work involves a lot of people, and we determined that this unit can run safely until January turnaround.
I also think the testimony is clear that in part, to avoid the catastrophe, they ramped down the system so that they knew that they could operate it safely until the turnaround occurred. That's what the testimony is.
And that was the question, is the catastrophe to which you refer in your declaration, is that a catastrophic event that could occur if it's not, these tubes are not replaced and the unit is run at full capacity, the heater is run at full capacity?
That's correct.
Okay, so it is not that there was a catastrophic, that there was a possibility of catastrophic failure between March of this year and now, or January, because you were running it at half capacity?
We ran at extremely low capacity.
Okay,
May-
and what, but now you wish, that the purpose of replacing now is that you would like to run the heater as it is meant to be run. Is that correct? Without catastrophic
Also to
event?
get also to fix the leaking part as well, right?
May I clarify one issue?
Yes.
Catastrophic failure, I think is the term utilized, is not the same as catastrophe. Catastrophic failure means a complete breakdown. It doesn't necessarily lead to a conclusion of a catastrophe.
Thank you, that's helpful too. Dr. Lerner, if you have a question. Do you have a question?
Well, let me respond to that. Does it exclude the possibility of a catastrophe?
I'll defer to the witness. I think that's who you want to have answer that question.
First question in the first place.
What was the question? Sorry, I didn't understand your question.
Could you just repeat the question, please, for the witness?
Does the term catastrophic failure include catastrophe, period? Something terrible that might affect the community and your employees.
Could be.
Thank you.
I just have
Ms.
one
Byrd
follow-
and then Mr. Balagopalan.
I just have one follow-up. So you mentioned that, that you wanted to do this to repair, to prevent catastrophic failure. But when you switched to running, when you minimized the use, didn't that take away that possibility of the catastrophic failure? You know what I'm saying? Am I saying that in a way that?
Yes, sorry,
Okay, so the reason that it could be a catastrophic failure would be if you continue to run it the way that it had initially been run, as opposed to minimizing the run, cutting it down, ramping it down, bypassing. When you did that, you removed the possibility of the catastrophic failure at that time. Isn't that correct? Okay. So the only time that there would be a catastrophic failure, it would be if you ramped it back up and ran it the way it was running. And that's still the possibility of catastrophic failure. I'm not saying it was a catastrophic. So at the time that you determined that there was a leak, you removed the possibility of catastrophic failure by changing your operation. Is that correct? Okay, thank you.
Mr. Balagopalan, you had a question?
Yes, Mr. Sharma, do you recall of a time when you had to do repairs to the heater unit, but you didn't have to take down the stacks?
Well, so I guess each heaters are different. So this heater particularly has basically stacks to be removed to get to the convection section tubes. So mostly, normally we don't have to remove stacks all the time, but in this situation, yes.
But let's say if you're not doing repair to the convection tubes, maybe to the burners or something, do you have to take the stacks down too?
No.
No. So my question is, do you recall in your time there if there was a time when the repairs were done when you didn't take the stack down?
You're asking if he has personal knowledge?
Yes, personal knowledge, yes.
I normally don't deal with turnarounds, sir, so.
No. And when, put my prop up so it helps me, when this units are up and, but they're two stacks, right? So,
Yes.
okay. 40 feet high, am I right?
I think so,
Okay.
yes.
And I think 7 feet in diameter, so they're huge stacks. The variance is, of course, to not report, I'm sorry, let me back up. When the unit when you go through the shutdown mode and you shut down the heater, and before you take the stack down, what data is transmitted to the district?
So until So SIMS will be in operation until heater is completely shut down and fuel flow is completely cut off.
Right.
So we report all the required data until then. So like NOx, SOx, O2, everything.
So the moment all that is stopped, I mean, it'll take a few days. I mean, once you, I'm trying to understand is, when you cut off the fuel and the heater is not operating, you don't take the stacks down right away because whenever.
That's correct.
So in the meantime, until then, what data has been transmitted to the?
NOx and SOx are transmitted daily to AQMD.
No, the heater's not operating. So when I'm saying when the heaters, in your, what you're planning to do is you're planning to shut down the heater, cut the fuel. You have tag in, tag out procedures, and one of them is putting the flange, the blind flange in. Once that is done and there's no fuel flow, there's no NOx emissions, but the stacks are still there until you take it down. There might be a few days or whatever it is. What data gets reported to the district?
Everything.
Could you clarify, are you asking for hold on. Are you asking for qualitative data or quantitative data?
Quantitative data, yeah. I mean, is it the status code saying non-operational? Is it, because you're not sending NOx data, I mean, zero,
We're
basically.
still sending NOx 0, SOx
Zero,
0,
SOx
O2
zero.
21%, and fuel flow 0, because our SIMS is connected to the RTU and we
So
transmit.
you are sending, so, okay, so you're
Absolutely.
sending zero,
And
basically.
all the status tags, everything goes to AQMD.
Right. So the ones then you take it down, I mean, to take it down, you have to, again, you have to take, what are the steps you have to do to take down the stacks with the SEMS unit, besides taking the probes out and what?
Well, I think, so they normally have control shutdown, and we have SIMS contractor who does control shutdown of the SIMS, so not to damage the SIMS. Then they go through step-by-steps like probe, heated line, condensers, everything step-by-step, so they have their own protocol.
Okay, so, but the power is completely turned off?
Absolutely, correct.
Okay, thank you.
Any other questions for Mr.
Let
Sharma?
me ask a question.
Senator, since the beginning of this hearing, I have asked you if you have had questions, so the theatrics are not really useful.
I'm not on the stage, I'm just asking a question. My question is, you talked about when there's a leak, you bypass the leak, is that correct?
Yes,
Is that like a redundant system operation?
no.
Okay, the question was asked, catastrophe or catastrophic? Catastrophic, does that mean a failure of the system?
Failure of the heater, yes.
A catastrophe in your mind then means what?
So when heater fails, probably you will have unnecessary emissions come up from the heater, right? So unburned hydrocarbon, all kinds of NOx, SOx, anything could be,
Could it be an explosion?
I don't know. I'm not expert, sir, so.
Maybe next time we'll bring some, we're going to answer some of the questions. Could it be an explosion where people could be harmed in any way, or you don't know that?
That's my understanding.
That's your understanding, could be.
Could be.
Oh, yeah, serious matter. All right, thank you.
Anyone else? Okay. Thank you, Mr. Sharma. We'll take a break. Let's go off the record and come back at 10:40. Before we do, though, Mr. Weiss, you will not have another witness, or will you have another witness?
We do not intend to present another witness, correct?
Okay. So when we come back, I believe we had a legal question, and perhaps we could have a witness from the district. Okay. Or Ms. Feldman might be able to answer. Okay, we are off the record until 10:40. We're back on the record. So we were at the point where I do believe Mr. Balagopalan still had a question. Did you still have a legal question you wish to have answered?
Yes, I can address that. It's about the nature of the violation, am I correct?
Is your, I don't think your thing is on. There.
Okay, so they, the district had said they will issue a notice of violation if they don't get a variance today. Is that,
No.
no, okay, if they don't get a, so if they don't, if a variance is not approved today,
They could get a notice of violation.
it could get a notice of violation. So we have to make the finding if there is going to be a violation or a potential violation as one of
That's the first finding.
First finding, yeah. So, and that's why I'm having, and maybe you can help me here, is because we know nothing is going to, the system is down and the stacks are down. So even if they they cannot operate the SEMS because it's down. So,
Yes. I understand where you're coming from.
Okay.
I can direct you to the appropriate part of the permit that they will violate. It's stated in the papers. If you go to the petition, which was prepared by Tesoro, and go to attachment C,
okay,
you'll see section F of their facility permit to operate. Those are the reclaim monitoring requirements. And you look at A1. It says that the operator of a NOx major source shall, as applicable, install, maintain, and operate a district-certified monitoring device or approved alternative device.
I'm sorry,
A1.
A1, so, okay. Yeah, hold on. I'm not-
A1,
okay,
yeah. To
one.
continuously measure the concentration of NOx emissions.
Right,
They can't do that with the stacks down. You've heard testimony that when they don't take the stacks down, they report 0. That's what we expect. That's what the rules require.
Right.
So just by virtue of the fact of there being no emissions to report, doesn't mean you're excused from the requirement to report the emissions. Similarly, just because your stacks are down, the requirement to have an operational SEMS or ASEMS is still there. So they must get a variance in order to take out the SEMS, to not operate the SEMS. And if you go further down that page to 4, it shows that the operator has to use valid data collected by the SEMS,
right.
right? So there will be no valid data because there will be no SEMS. They're in violation of the rule that requires that and the permit conditions that requires that once they take all that equipment down. Impossibility doesn't necessarily excuse you from compliance with the rules. That's what a variance is for.
So my question is, why didn't the district then use enforcement discretion in this kind of situation instead of?
That is exactly what this process is designed to limit. There are many instances where the district, almost every time there's an unopposed variance, where the district thinks that a facility should not have to comply with a district rule for a certain period of time. What makes this whole system impressive to me, because this is virtually the only jurisdiction in the country, California, that has a variance system like this in place for environmental regulation, is that we make the process public so that deals are not made behind closed doors to excuse facilities from operating, even when it's just a technical violation. We require that they appear as part of a public process so that the community has an opportunity to testify, even though that's a rarity, and that a board has an opportunity to make an independent evaluation.
No, I understand that, and the public, but, and we all know there are no emissions, the public are really not affected. In fact, you see
Right.
a temporary period reduction for 45 days of emissions during that period.
Right.
But even, I'm still sort of, they cannot, I know it says you have to continuously measure the concentration of NOx, and they cannot do that because it's down. There's,
Right.
they,
And if I may just interrupt, that's why we thought this was really suitable for the consent calendar, because this is such a technical violation, but a violation nonetheless, that involves absolutely no excess emissions. But to suggest that we would grant what we like to characterize as an administrative variance, in other words, a variance granted by the executive officer of the district, is not appropriate when the legislature has determined that the hearing board is designed and charged with the responsibility to make a decision in these kinds of cases.
no, and I truly understand when, if they are able to do it, but they're not, it's a I mean, they are completely shut down. Even if they wanted to, they cannot, so.
Oh, I agree, and that's why we tried to submit this on the papers.
And is there another, at this point, I would say, is there another question? Because I think that's the back and forth, and I think
Yeah,
Ms. Feldman
true.
has answered for
And
the district.
Do you know, well, it's not, I was citing 1110.2 and and that's for engines, and they did say if, the operator is aware the system it's not in operation, they don't have to, they can stop operating and calibrating. And the rule, which means they wouldn't be in violation, basically. Do you happen to know why that was put in there, or,
Oh, no, I'm sorry. I don't know why it was put in 1110. And I can draw your attention, you could take notice, that in the reclaim rules, there is an opportunity to designate equipment as non-operational, and then you are excused from the SEMS requirements, but that's a process. Probably not appropriate to use when you're only taking equipment out of service for 45 days.
right, when it's
Right, so,
completely out,
yeah.
yeah.
Yeah, so, we try to anticipate in our rulemaking when certain situations will arise to avoid things like having petitioners have to constantly come to the hearing board for variances for the same sort of thing multiple times during the course of a year, or many facilities once or twice a year. But in the case of refineries with turnarounds and startups, as the senator mentioned, which could result in excess emissions when you take equipment down and then restart it, we would rather it be evaluated and heard through a public process.
Okay, thank you.
Senator?
Public means a board hearing, not consent. Let me ask you a question. You mentioned the legislature gives
Wait, may I stop you there, because that is not correct. Consent is a public hearing. It merely means that the parties do not come, but the public has been noticed, and the public may come and give comments. It is the same public hearing.
But unless you have a full hearing, the public won't know what's going on.
That's not true, because we also are required to deliberate and tell our reasons why we do or do not make a motion and make findings and grant or not grant a variance.
If that motion is not approved, then of course, and they're not here to explain why it's not approved, then the public won't get notice. Anyway,
We are
nevertheless,
here, regardless of whether it's on consent or not, we deliberate publicly. I want that to be clear on the record.
well, I'm a public member, and I think they should have full knowledge, and that's why we're here today.
And they do. Again, to be clear on the record, the public notice is the same. The public hearing is the same. We merely do not repeat witness testimony, but we deliberate the same as if it were a full hearing. The deliberation we are all going to undertake in a few minutes is the same whether it's on consent or not.
If this item were not taken off consent, the public would not have heard this discussion this morning related to this subject matter, would not have heard
They
it.
will hear the relevant discussion as relates to the findings when it is the appropriate time, whether it's on consent or not.
Then the chair would determine what's relevant. Irrelevant.
No, the entire 5 members of the board would deliberate as they do at every hearing. Again, I don't want to have an argument. However, I do want the record clear and correct.
Well, I agree with you. The record should be clear, correct, and should be noticed by the public. Now, my next question to you.
It is.
Oh, thank you, Madam Chair. You're very kind.
And it is webcast currently as we
because
speak.
Only because it's off consent.
That is not true. Again, I will state it for the record. Consent is the same public hearing. We come, it is webcast. It is noticed in the same exact manner as a regular hearing. We deliberate on the record, on the webcast, in a fully noticed public hearing, the same whether we are on consent or not on consent. And that is a very important point to be made. And if it's not understood by the hearing board members, that is a problem.
And of course, since you elaborate on the question, on the point, the petitioner presence is not necessary if it's on consent, yes or no?
That is correct. And as a matter of fact, that could be a detriment to the petitioner, because if a member of the public comes, the member of the public may speak, because I will ask for public comment, because this is a public hearing. And if the petitioner chooses not to show up, but instead to put the matter on consent, then the petitioner cannot answer. So if something is raised and the petitioner is not there to answer, that could be to the detriment of the petitioner, not the public.
Somewhere in the petition, I think it reads that they didn't have to give a 6-day notice, but short variance required 10-day notice.
What are you talking about?
Oh, never mind.
Okay.
Let me
Anyway,
ask you
the
a
notice, I'm going to ask the clerk right now, and then you may ask your question. Madam Clerk, was the notice provided for this hearing? Was there a 10-day notice requirement? Was it complied with in this matter?
All noticing requirements were met and complied with.
Thank you, Madam Chair. Madam Clerk. I don't know if that's a promotion. Senator, please, your
Sounds like a
question.
good title switch to me.
Your question, Senator.
You saying the legislature granted authority to this board to deliberate on this issue. I think that's what
Yes, sir.
Right?
Yes.
Right. Well, did the legislature adopt these rules, or
No, that was the governing board, as you well know.
is the governing board? So therefore, if it's the governing board rule, then of course, could that rule, for example, in the event where the system is shut down, then is the rule then rendered ineffective?
Yes, it is.
Rendered ineffective. That's the point that was being made earlier.
No, I thought you asked if
Is the rule
effective.
rendered ineffective if you don't cite them?
If you don't cite them.
I'm sorry, I'm confused, and I
If-
need to
Are
follow
you
this.
suggesting
So.
that the rule is ineffective unless
If
they
the
get a
rule
notice of
says that
violation?
the SIM
Yeah,
or the
ASIMs.
ASIMs are not in operation,
They are in violation of
They're
the
in
rule
violation.
requirement, yes.
okay? But then the question was asked earlier on, how could they be really in violation theoretically, if there's no omission?
I don't deal in theoretically. I deal in what does the rule require?
In reality, then, could there be any emission at levels at that point in
There are
time?
no emissions associated with this variance.
It's just a requirement that the
Just a
rules,
requirement that they maintain and operate a monitoring device in the stacks,
even though
the stacks are down
it's not in operation.
and it's not in operation.
That's pretty good, huh?
Yeah. Works for us.
I just want to note, thank you, Madam Clerk, that the clerk handed to me the posted notice for this matter dated December 5th, 2019. And that was the notice that was given, as it would have been given whether it was on or off consent. Thank you, Madam Clerk.
If need be, I can also provide proof of publication in the newspapers.
Thank you.
Oh, did I do that? Thank you. I don't think it's necessary. I think we're just making the point, but thank you. Are there any other questions for any witnesses? Again, that is not covered in the declarations and the evidence we already have. Oh, Ms. Byrd.
I don't want to beat a dead horse. I just want Ms. Feldman to say this again. I believe your statement was the impossibility doesn't excuse you from compliance with the rule.
That's right.
Okay, thank you.
If you can read, then everybody would understand that.
Okay, I'm going to ask at this time if there's any member of the public who wishes to be heard. I see none. Mr. Weiss, your closing.
Thank you. I always thought, no, I won't go there, never mind. I have a very lengthy closing because of everything we've heard, but I'll truncate it down to about 5 minutes or less, hopefully. First off, thank you for your time today. We appreciate your attendance and listening to what we have to say. Again, as I stated previously, we think this is a fairly straightforward scenario, that it's one that the board has seen previously. We have a scheduled turnaround that's occurring on the basic equipment. Tesoro is taking the opportunity while that's happening, and because the SEMS will be down, to fix some additional equipment within the heater. To do the work, the heater is going to be disassembled. The heater will be disassembled. The fuel line will be blocked. There will actually be a gap in the fuel line, between the fuel line and the heater, to ensure that there will be no fuel going to the heater. That's how we can all be certain that there will be no emissions associated with the variance. The district rules require the SEMS and the ASEM data at all times, but we're not going to be able to do that for a very short period of time, as described in our papers. I think it's very easy, based on the papers that we have submitted, based on the petition, based on the testimony that we've elicited today, and based on all the documents submitted in our request for a consent calendar petition, that all 6 variance conditions can easily be made and found, and that the AOC requirements can also be found. The rule and the permit conditions that we seek a variance and AOC coverage for are clearly stated in the petition. They're reiterated in a couple of other places as well, but those, I'm not going to go through them all. They're fairly lengthy. If the board would like me to, I can, but I'm going to try to truncate this, as I said. So the rule and the permit conditions that we seek a variance and the AOC coverage for are clearly presented in the documentation that you have, and that we've also provided a findings and decision that was stamped in by the clerk on December 20th. The finding and decision and the order, and it clearly defines the conditions under which the petitioner will operate during this variance and AOC period. We can go through those again if you like, but again, I want to keep this as succinct and direct as I can. It's all very clearly stated in the documents. With that, we will submit.
Thank you, Mr. Weiss. I actually had just one question, which is really a technical thing, but while you're here, I might as well ask. You've asked, or at least you've placed in the proposed findings and decision, that the AOC would begin at the date of the stamping or the submission of the petition for AOC, which I understand is allowable under Rule 518.2. I wonder if it's necessary, or can we have the same start date of January 7th? And I'm specifically looking on page 13 of Exhibit 2, line 27, paragraph 7, which again cites the subsection of 518.2 and says that the AOC shall become effective on the date the petition was filed with the hearing board. And having no evidence in any of what was submitted to go back farther than January 7th, I wonder if we can just align the AOC and the variance.
Give me 1 second. So the reason it's presented that way is that for the AOC, the EPA has a 45-day period to which they can comment, and so we thought it made the most sense to start it as indicated in the findings and decision.
Understood, and as I said, that is allowable. Okay, thank you for that explanation. Ms. Feldman?
I'll keep my closing extremely brief, just because I'm reflecting on my statement that impossibility does not excuse compliance, and it doesn't, because only the hearing board can excuse compliance. That's called a variance. Impossibility may establish, and often does, a very good basis upon which the hearing board makes the second finding, that it's beyond the petitioner's reasonable control to comply with a rule. But the way many of our rules are crafted, including the ones that are the subject of this petition, just because you can't doesn't mean that you're not in violation. And that is why Tesoro is here today. Thank you.
Thank you. I'm going to ask my fellow board members if they'd like to discuss the findings, but before we do, I think it's very useful at this point just to have a really brief discussion of what occurred today. I think we started this hearing with a lot of frustration. There's been some other emotions, I think, flowing around the hearing board room, both on the side of the hearing board members as well as the parties. And I just want to bring us back to the reasons why we have a consent calendar and what our rules do actually say, just so that we're all on the same page when we begin our deliberations. The idea of consent calendar, the whole rules regarding consent calendars, that is adopted by this board. And the reason why is not to hide hearings, not to make them less public. In fact, we have no ability as a hearing board to cut back on public notice requirements. Those are set forth by state law and the Health and Safety Code. Rather, the whole point of consent is merely to cut down on resources, judicial resources that are unnecessarily spent by long hearings, resources of the parties, if it's not necessary. And so we have very specific guidelines laying out what types of matters can be heard on consent. And they generally are those where both parties are in agreement, and they are in agreement as to all of the relevant facts. And all that really needs to happen is for the board to deliberate publicly, and then to discuss whether or not all of the 6 findings can be made. Certainly, every board member has the right to vote no, as does every board member have the right to vote yes. Whether you plan to vote no or yes is not relevant as to whether something is on consent. Rather, it's whether all of the important questions that you need answered, all of the important, relevant facts are on the record, or do you need a hearing to further gather evidence that you do not have. So that is the purpose of it. There's no nefarious purpose. So I wanted to make sure that that was out there. With that said, every member of the board under our rules has the ability to withdraw or to pull a hearing from the consent calendar and to ask for those witnesses to appear before the hearing board. They do not have to give a reason. Hopefully, it's because there actually are relevant questions they have unanswered. However, that is the right of every board member. So I just wanted to lay that out there to frame our discussion, because I know that that was the elephant in the room. With that said, did you have
Before
more
we
to say?
begin discuss
Senator, please.
the 6 reasons for variance, I think a discussion, follow-on discussion, is relevant, and I'm glad you opened it, Madam Chair. Let me just say to you that, in my view, the integrity of the board should not be challenged. You're here today because a member of this board removed this item from consent. which they have the authority to do. It may have been an inconvenience for some to travel here during the holiday, but that's not the way the system works. We're charged with the responsibility by the legislature to clean this air, this environment, as best we can by employing the legislative action and the rules and regulations adopted by the board, governing board. And that's why we're here to do that. This district has held a lot of petitioners, providers, or polluters, feet to the fire. Things have gotten better since this district has been in effect than it was prior to it being created. You can breathe better air, it's clean. They're diligent and hard workers. They do a very good job. They set an example, not for the rest of the state of California, but for this nation, as I view their performance here in this area. Surely, quite tough questions are asked, and they're looking for answers, and they should be asked. No one should take these rules lightly, or shall we say, circumvent them or the process, or game the system. That we're not here for that. Now, let me just further say that during this discussion, one key word or two, catastrophe, is relates to the failure of the system, because you said that catastrophe relating to the failure of the system. Catastrophic, then you say, but a catastrophe, no, catastrophic, a catastrophe related to the failure of the system. A catastrophic situation, maybe unless I got it in reverse, could mean that something could happen like that. But for your information, there has been a catastrophe at this facility. It's been testified to that it could be an explosion. It so happens that I bought a car from a dealer adjacent to this facility, and they did have an explosion. They talked about the building almost moved when that explosion occurs. When that water shuts down, the leak occurs. If it's not a redundant system, the other one fails, you got that kind of a problem. We ought to be concerned about that. Those issues should be raised. And that's one of the other reasons why I call it special. I mean, taking it off consent. I want the answers. I'm thinking about the public safety, and I'm sure the other members are as well. I just happen to have a little bit more insight in that regard as relates to this facility. I'm sorry you had to come out today, but let me just tell you this: this discussion has been beneficial to me. I read this thing from cover to cover. I know what the district required you to do. I know what you've done in order to fix the problem to the best of your ability. And so it all came out in testimony. But never at any time, in my view, I'm never going to throw you a softball. Some of the questions that were put to you, like a softball, where you would answer yes. Of course, the question should be posed by you, and then let's answer yes or no. You never get a softball from me. You got some today. You should be grateful for them. In any case, you've done it. What we have before us is what we have before us. And thank you for coming out.
And okay. I'm just going to start with the 6 findings and move us along. I can make the findings, and I'm going to, other members will have a different view in terms of what they needed. I am able to make the 6 findings based upon the declaration and the evidence as it was already provided in the consent calendar. The consent papers, and I'm going to refer to those in my recitation of the 6 findings that I can make. I want to first frame it, and I think the way that it makes sense. I know there was a lot of very strong words, I think unintentionally by the petitioner, thrown around during this hearing, which obviously would make I think, the public who might be viewing this a little bit concerned. However, the way I view this variance request is that there was an unexpected, based on the fact that almost immediately prior to these tubes, the convection tubes leaking water, there was an inspection, and the inspection showed no issues. So in my mind, it was unexpected. It did happen in March. However, I do believe that the petitioner acted in terms of bypassing the portion of the heater with the convection tubes that were leaking and running at half capacity. What is being requested of us today is simply to do the repairs that need to be done and the replacement of the tubes that in fact have been leaking and not used and have been bypassed since March. And the request is being timed, in my mind, with a turnaround, which we understand, again, from other hearings, that turnarounds do take a long time to plan for the reasons that were explained by Mr. Sharma in terms of the many experts that need to be brought in, et cetera, and the fact that so many things get taken down during the process and have to be timed to be brought back up. And I think that the importance of stating that for the record is that I think the petitioner, in part, I'm sure it's also so that they don't have to shut down twice. That has a financial, I'm not going to pretend it doesn't, benefit to petitioner, but it also, we know, have emissions benefit to the nearby communities, because every time these processes and equipment are taken down, they have to be started back up again, and we know it takes a while before the control devices come up to speed or temperature, et cetera. And so there are always excess emissions. And so by asking for it to be timed now, they are in fact reducing any emissions. There are no excess emissions, but we'll get to that in a moment. So with that as the frame of what's being asked, for proactively to do the maintenance, and all that they're asking for is a very small variance. Again, they are currently in compliance with all rules and regulations of the district, including emissions limits. What they are asking for is simply to not be in violation of the rule that just requires them to operate as SEMS, even though the stacks are taken apart, the heater is not being run, and it's being flanged or whatever it's being, and shut down. So with that said, the first finding can be, I believe it can be made. I know there were questions by Mr. Balagopalan. Definitely it makes sense why in this situation in Rule 1110.2 is it allowed that SEMS comes down. It's not for us to question it. I know Ms. Feldman made a very good point. Oftentimes, exceptions are not made in rules so that the hearing board of this district can, on a case-by-case basis, not allow exceptions to be, sort of get a foothold in an exception and make it broader than it should be for many reasons. We're not here to question the reasons, but just simply to note that, in fact, there are a number of rules and permit conditions that are stated in both the petition and the proposed findings that will be in violation when the SEMS is taken out of service, even though the heater is turned off and there are not any emissions. I believe it's beyond their reasonable control. Again, we did hear that there was an inspection previously. The leak was unanticipated. Regardless, it is beyond their reasonable control not to fix it. They need to fix it. If they don't fix it, they can't use the heater. If they use the heater and they don't fix it and they go back up from half usage to full usage, that is when the catastrophic failure could occur. And so I believe it's beyond their reasonable control. And it would be, I believe, an unreasonable taking of property to not allow them to fix the tubes because of this technical issue, or to replace them, and to fix the heater. I believe it's without a corresponding benefit in reducing air contaminants. The AOC and regular variance we should be bifurcating this now that I'm saying the AOC. I'm talking first about the variance. The variance conditions require them to isolate it, to turn it off whenever the SEMS is out, the stacks come down. The heater is not being used. They have to monitor the fuel usage to ensure that the heater is not being used, and so there are no excess emissions. Curtailment is not an option. They're actually shutting down the heater. That will not obviate the need for a variance because of the technical nature of the variance request. Reducing excess emissions, not applicable. There are no excess emissions. And as I stated, monitoring is taken care of in terms of when they're shutting it off, fuel usage is being monitored, showing that there will be no fuel usage during the variance. Anyone else have any? And I know I did this in the middle, but we're talking first about the variance, and then we'll get to the AOC. Dr. Lerner and then Ms. Burt.
Yeah, I would like to chime in, and I agree entirely with the 6 findings. I would like to just, if I may, take a little bit of disagreement with you. You know, we all know the story about the little Dutch boy putting his finger in the dike. Now, the inspection, if I heard correctly, was done a week before, and then subsequently we had a small leak. Well, small leaks large leaks can happen catastrophically. I mean, excuse me, bad word, suddenly, but small leaks can become large leaks. And that's what I was getting at. After all, you have a very highly complex company, and I'm not being critical. You've been here 116 times. This is the 116th time. And I just want to say, based on some experiences that I've had with Tesoro, sitting here naively, of course, as a physician, that I don't want a small infection to become a large one and then lose one's arm. That's what I'm getting at. And furthermore, I would, if I were the king of Tesoro, I would demand, fix it now, do the turnaround early, let's put it all together quickly. That's why I was harping on this issue about March to November. Coming in at the end of November is perfectly legitimate from your point of view, but from my point of view, it should have been done earlier. We do get boxed up here, but that's our problem. But the important problem for you guys is to prevent a problem. This is a preventive thing. The turnaround is a preventive thing. And the fact that you found this early would make me be very worried, since you already probably knew in March that the turnaround was going to be in January. So hopscotching backwards and getting it done in the summer or spring or early fall would seem to be a much more rational and therefore preventive kind of approach to this. I think that I may be alone in this on the board, but then I am the only doctor on the board. Thank you.
Ms. Byrd.
I just wanted to say that I could also make all the findings, and I could have made them with the documents that were submitted on consent as well. There was a leak found, possible hazard. The hazard was mitigated. A repair was scheduled at a time that was convenient to minimize emissions as well as to not have as much of a financial impact. That's the reality. And so I could make the findings based on the documents that we received. I did just want to, I agree with you, Ms. Prusak, on every one of our hearings is a case-by-case situation, and we're not here to question the rules. We have to understand them in order to apply them, but we don't get to say what the district should or should not do. We have to follow the district's protocol and follow the rules that they've developed. There are reasons that they exist. Sometimes I question it myself. I don't, that doesn't seem like it should be. But it is what it is, and I didn't do the research for it, so I'm not going to try to change it. And I think that in this case, this was one of those cases I must agree with the district that this was a case that definitely could have gone forward on consent based on the data that was presented. We would have covered all of the findings when we went through it on consent if we had gone through it on consent. So for those reasons, I can definitely make the findings.
Mr. Balagopalan.
Yeah, I think I'll reframe it a little differently. I think the issue before is operating the SIMs, really, when the heater is taken down. It's the heat. I think the issue of when did they know it and when they're doing it and they're doing it appropriate. Is it appropriate to do in the turnaround? That I'm not going there, but I think the issue before us is are they in violation if they cannot continuously monitor emissions during the time the stacks are taken down. I heard Ms. Feldman say that impossibility does not excuse compliance, and I hear that, and but I have a but here. We have a number of permits that are issued that says, your furnace went to a bag house, you cannot operate furnace unless it's the bag house is operating, vice versa. So one is shut down, just as an analogy, they'll shut down the bag house of the furnace because there's, nothing to control. Or even the opacity monitor or the broken back detector on the bag house is also shut down because the main furnace is not operating. I think I don't have a problem if the stacks were up and they said, this is a good time, this is a turnaround time, this is a good time for us to do maintenance on the probe or on the SEM system because this gives us an opportunity, and then come for a variance because they don't want to operate it when they could. Then I think it's a different situation. It's a slight, I see the little difference here, they will operate the SEM, even though the rules say, yeah, you got to operate on SEM, it just does not make, I won't use the word, so I'm having still the difficulty, when I saw the language in 1110.2, I say, oh, okay, and I could not find why they did that. I looked back, it was in 2012, it was amended, but I did it was a 900-page staff report, but I did some keyword search, but I could not find any specific language, but they just said for clarification. But I was like, oh, okay, I'm not far out here, left field. It looks like somebody has made a change to address that issue. So for that reason, I'm going to stick with not being able to find the violation here. I think the proper procedure, in my mind anyway, and is what they are doing, is to notify the district that this is going to happen, notify, and then, all the data has been transmitted to district when they can, and then they notify the district. I mean, they got tag procedures. I think they mentioned one here, but they got a slew of, I'm sure, at a refinery they have to do for safety reasons. This is not the only tag procedure, that they have. And then to notify the district when it's up and running, the inspector can be up there watching and, checking. And if they have it up and if it's not running for whatever reason, like the rule requires and the condition requires, then give them a notice of violation. Because the rule requires, says, hey, if you can operate the SEMS, you have to have it running, even though there's no data been measured. You transmit zero, whatever. So on that basis, I'm going to have to, I respectfully, Ms. Feldman, I think you made a convincing argument, but I'm going to say, I still have, I'm struggling with that, and I'm finding it difficult to find the first finding.
I would like to respond to that as the legal member of the hearing board. I'm going to give you a little, I don't want to say lesson, because that's not, I want to just talk statutory construction 101. Okay, so when we're looking at a rule that is written by an entity, in this case, it's the governing board or the district, the first thing that governs when you're looking at is the plain language of the rule, and that's whether it's a permit condition or it's a rule. The plain language governs. If the plain language says you must operate continuously, then you must operate continuously. If it doesn't give an exception, there is no exception. Whether you think it's a smart idea, the enforcement should be different, does not matter. Now, if you want to reach out further than that and you want to look at other rules that do give us exceptions, in fact, that further proves that there is no exception. Because generally, when we look at statutory construction, they'll look at the rules of the district. And if one rule calls out an exception and says, under this rule, the SEMS can continue, or you don't, you can disconnect the SEMS, and that's okay on these situations. But it doesn't say that in another rule. The implication is that you must continue in that rule. So if it doesn't, it's just more, it just further bolsters that the plain language speaks as it is. So I also want to go back to, because I know we had this issue in another case, and I just want to remind us all that when the district makes an interpretation of its own rules, they are going to enforce, they have the right to enforce. So that puts, if we do not grant variances on the grounds that we just can't, we don't understand the rule, and even though it says it, we don't think it makes sense, and the district is saying they're going to enforce it as the district, or maybe they won't, but that is, we don't want, as Ms. Phelan was saying, we don't want the district running amok and just making behind closed doors decisions not to enforce. Lost my train of thought. I think we need to, I'll go back to, because I think I lost my train of thought, but the point is, this is what I was going to say. It puts facilities between a rock and a hard place, because they're being told that they're going to be in violation, and they're going to receive a notice of, they could receive a notice of violation, but the board is saying, we're not going to give you variance relief from this provision, because we don't find that it is. But we're not the ones who are relevant in terms of, it says it, and I'm just going to say, we don't want to have a situation where we are constantly putting facilities between a rock and a hard place because we disagree with the interpretation of the plain language of the district's rule. So that's all I would say. Dr. Lerner, you had more to say.
May I ask my colleague a question for clarity's sake, because I'm not familiar with how things are measured in a stack. If you take the stack and you can remove it and you can lay it horizontally, does that automatically disconnect the monitoring device? Or can the monitoring device be plugged in literally into an extension cord and keep monitoring and resolve the problem? I don't know.
I believe that's covered in the, we should.
Yeah, the short answer is
It may
no.
be covered, but I did miss
We
it.
should refer to the declaration if we have that question, and we could find that answer.
And I think in their declaration, they said, no, they cannot, they have to take it down, they have to remove the probe and so forth. I think you heard testimony also that they have to bring in the SEMS folks in to do all that staging to take it offline. Mr. Sharma made that, so they have to go through that procedure to take it offline.
Okay, just like to make one final comment. I want to congratulate you on presenting a very good essay on your behalf and the presentation of the stipulation. I thought it was very good.
Are you talking about the declaration that was?
Declaration, excuse me.
Okay, and that was for the purposes of consent. I wanted to, before, Senator, I know you wanted to speak, I just wanted to respond also to the point that was made by Dr. Lerner. I think it's a very good point. I think, again, though, I can't go into the 50, I can't go into the minds of those who are in charge of running this facility and the decisions that were made. They seem like they're extremely complex decisions. But I can understand the concern of what seems to be waiting for a long period of time or for several months. But I will go back to beyond reasonable control, and I just want to reiterate my finding that they are not out of compliance. There is there's no violation. There hasn't been a violation for the last few months. There's never been a violation. And I believe that I can make the beyond reasonable control finding very easily because they must replace the tubes. We're arguing as to how quickly they could do it or should do it. They have to do it. And in order to do it, they have to take the SEMS out of commission. And that's what they're asking for, just to be able to technically take the SEMS out of commission. So for that reason, I can make the finding. Senator?
First of all, I began by saying that this board cannot make or break any rules. the governing board makes the rules. And we all clearly understand that, or should understand it. I just wanted to make that point. Let me also say that in the declaration and also in findings and decisions, they talked about the 6 findings why the variance should be granted. I think they addressed the issues that if it were not granted, what would happen? So in the first finding, it says that the petitioner for variance is or will be in violation of section 41701. Is or will be in violation. It's been explained in the documentation before us that if it's not granted, then they will be in violation of the section. So that finding is clearly addressed in the petition. I just raised some other issues because I felt they should have been raised early on. As the doctor mentioned, you've been before this board 119 times. Therefore, somebody that's kind of not adhering to policy as prescribed.
Variances are not having to do with violations. This is not I just want to be clear, 119 times doesn't mean that they were in violation and were before us for a...
Did somebody should explain to me why it numbered 119 times?
They have a lot of pieces of equipment. But regardless, I also want to be clear, we do not hold it against a facility. Other cases which are not currently before us, we take each thing case by case. We make the findings
Madam Chair.
on the evidence in the present moment.
Madam Chair, I've been in the council for 16 years and the Senate for 4. I understand the policy, and you address the issue. You vote based on the facts and evidence presented on the issue before you. I understand that. In the final analysis. And so what I'm saying is that you've explained it in this documentation here, but because I know there's been some explosion in that area emanating from this facility, I've had some...
And I should stop because I didn't say this before, but there are no explosions on the record. Let's stay away from discussing anything not on the record today.
Well, it wasn't discussed today, but it has happened. As it stated that by the witness, he said explosion could, in fact, happen if you had to leak. It became a catastrophic situation. That was mentioned before us. So in any case, once again, I repeat, the integrity of this board is uppermost in my mind at all times. And I'm never going to throw you a softball. I'll give you a fair hearing. That's all you can expect, and that's what you will get. And if you know anything about Nate Holden, you know what a fair hearing really means. Thank you.
I'm not going to respond. I'm going to make a motion, and I'm merely going to reiterate my initial thoughts on the matter, which is we want facilities to act proactively. We want facilities to do required maintenance. And when there's technical violations that have been brought to them by the district, if they were to simply disconnect the SEMS in this case with no excess emissions, we want them to act accordingly, and we want to make sure that they are able to do the maintenance that is required, and that's the way I view this variance request. Oh, before I make the motion, I think it would be, since the proposed findings and decision includes the AOC as well, I'm going to stop here and I'm going to discuss the additional findings that need to be made for an AOC. Then I will make a combined motion because that makes more sense, I think, in this situation. All the additional findings in 518.2 that I believe are relevant all have to do or stem from, for the most part, any excess emissions, which there are none, but I will go through them. Because this is not related to breakdown, that's not the reason for the AOC that's requested, and it's not related to startup or shutdown, or it's not resulting, I should say, it's not resulting from a breakdown, it's not resulting from a startup or shutdown. So all the findings that we made, or that I'm able to make for the variance, also I can make for the AOC. Sorry, I just want to find where they are in here. Okay, so in particular, the AOC will not result in noncompliance with the requirement of NSPS, NESHAP, or other standard promulgated by the U.S. EPA under sections 111 or 112 of the Clean Air Act, et cetera, and none apply while the heater is shut down, as I understand, and certainly there are no excess emissions. In addition, there are no excess emissions, so will not exceed any AOC credits in the credit bank, because there are no excess emissions for which credits are necessary. There will be no injury, detriment, nuisance, or annoyance to any considerable number of persons from the granting of this AOC. Again, the purpose of this AOC is simply to replace tubes that have been leaking and damaged, necessary maintenance. There are no excess emissions because the heater will be shut down through the pendency of the AOC, and so there will be no injury, detriment, nuisance, or annoyance to a considerable number of people. There also similarly will be no exceedance of any national ambient air quality standard because there, again, are no excess emissions. I don't believe there are any additional findings under 518.2 that need to be made, but let me stop there. Does anyone have any additional discussion on the additional findings for an AOC? Okay. Seeing none, I will make a motion. In the matter of Tesoro Refining and Marketing Company, LLC, case number 4982-119, I move that we grant the requested AOC and short variance, the term of which is spelled out in Exhibit number 2. I have the wrong thing. Exhibit number 2, the proposed findings and decision, but essentially it would begin on, I think it's January 7th, 2019 for the short variance. It has begun for the purposes of the 45-day review period for EPA for the AOC on the date that the AOC petition was filed, which was November 30th, 2019. Both the short variance and the AOC will, by the terms set forth in Exhibit 2, expire either on February 21st, 2019, or upon final compliance, as is spelled out in the conditions found in Exhibit number 2, whichever occurs first. Further, it is for the heater and the equipment that are listed. Well, I'm just going to refer to Exhibit 2. It's what is listed in Roman numeral 2, paragraph equipment that is the subject of this SVP and AOC, but we know it has to do with the refinery's number 1 reformer heater and the SEMS and ASEMS that are connected to it. It is from the rules and sections of the facility permit that are set forth also in Exhibit 2, Roman numeral 4, A, subsection A, which is found on page 3 and continues on from there. And it is for the Carson facility, the address of which is also found in Exhibit number 2, and it is on page 1, I guess the second page 1, because it's not the cover page, and it is at 2350 East 223rd Street in Carson. And I further move that we adopt the proposed findings and decision and order granting short variance. We will change it from proposed, delete that reference. Also, we would change any reference to the parties not appearing today to being represented by Mr. Weiss and Ms. Feldman. But I further move that we adopt the conditions of both and the AOC alternative operating conditions that are found attached as part of Exhibit Number 2, and there are no expected excess emissions, I guess of NOx or SOx, but of any pollutant. And that completes my motion. Is there a second? Nope.
I'll second.
Okay, Ms. Byrd seconded this time. Any discussion on the motion? Okay. Senator, how do you vote? Oh, did you have discussion on the motion?
Yes. Back again, or, just to make sure that it's clearly understood for the record and is being noted once again.
Do you want to discuss? Yes.
Emphasize that.
I think that's a good, so that we are clear on the record. It's always good to have that understanding on the record. I'm going to refer to, it's in two places. It has to do with both the short variance and the AOC, but I'm going to read directly from page 14, which I believe is for the AOC, and it's on line 1, and it states, the AOC shall end no later than February 21st, 2019, or when Tesoro certifies in writing that the SEMS and ASEMS serving the heater are again in operation and transmitting emissions data to the district on a daily basis, whichever first occurs. And the understanding, as was expressed, and I think Mr. Weiss is going to confirm it, perhaps.
I was just going to offer up the other location, which is on page 12, number 9.
But thank you. And that is the other, and I could read it, but it's exactly the same, well, it's not exactly the same language.
Same concept.
Same concept. It is, I'll read it. The variance period, so this is for the short variance as opposed to the AOC, shall end no later than February 21st, 2019, or when Tesoro notifies the clerk of the board in writing that the SEMS and ASEMS serving the heater are re-enabled and transmitting emissions data to the district on a daily basis, whichever occurs first. And the understanding by the parties and by this board of, and to the public, of whichever occurs first means that February 22nd, that this, neither the short variance nor the AOC will go past February 21st, 2019, barring a modification. And just for the record also, this is the way we generally state our terms of variances, almost always is stated in the alternative, whichever occurs first.
Right, that's fine. The reason why I wanted it to be emphasized, Madam Chair, because the short variance, they will grant as much as 90 days. Okay, so I just want that to be clear. They're not getting 90 days under any circumstances.
That is clear.
Thank you.
Okay, any other discussion on that, or shall we vote? Okay. Senator, sorry, did you have discussion, Dr. Lerner? No, okay. Senator, how do you vote?
Aye.
Dr. Lerner, how do you vote?
Expectedly, yes.
Mr. Balagopalan, how do you vote?
No.
Okay. Ms. Byrd, how do you vote?
Yes.
I vote yes. Motion passes 4-1.
Thank you very much. Happy holiday.
Thank you. Thank you for coming in today. Is there any other business, board members? Seeing none, yes?
Wish everybody in the building here a happy
I think you turned off your thing.
safe one.
I think you were off. We are adjourned.
I'm up.
Off and then you turned it